nature that might not matter to people outside of the realm of philosophy. What we're trying to do is to demonstrate that philosophy can and does have a really important impact on the way that we live our lives and the way that we think that we ought to live our lives. Next off, I would be remiss not to plug our philosophy of justice minor that deals with issues like this every day in the classes that you'll take. There's some information outside that you're welcome to pick up, or you're always welcome to talk to me about taking these cards out there as well, if you'd like to pick that up. With no further ado, I'd like to introduce to you Professor Adele Mercier. I'd like to read to you her bio because she's got so many degrees that I couldn't memorize them. She holds MAs from the University of Ottawa and UCLA, an MA in linguistics from UCLA, a PhD from UCLA in philosophy, as well as a CPhil from UCLA in linguistics. She generally works in, as you can probably guess, philosophy of language, philosophy of mind, related issues in metaphysics and epistemology, natural language semantics, philosophy of linguistics, and foundational issues in theoretical linguistics. But as you can tell by her presence today, her interests are quite broad. She also dabbles in areas of ethics, political philosophy, philosophy of law, as well as logic. I first met her because she was my logic instructor. She's taught philosophy as a visiting professor at UCLA, at the University of Barcelona, where she is a research affiliate of Logos. More importantly for the talk this evening, in 2001,
yes,
she acted as an expert witness in Canadian courts defending gay couples seeking the right to marry against the claim that I believe she'll take up today as well, that same-sex marriage is rendered logically impossible by the semantics of English. On a personal note, professionally, it's a great pleasure to be able to introduce Professor Mercier to you. But on a personal note, she has had a tremendous impact in the way that I live my life personally and the way that I am professionally, which some of you might blame her for. Passing of the buck. But it's a great personal pleasure to be able to introduce her. So please join me in welcoming Professor Mercier.
thank you very much. I'm very, very honored to be here. I'm very delighted to come to talk at the institute that my former student is chairing. It's a big thrill. And you live in such a lovely place. It was a beautiful ride coming here, and I'm very happy to be here. And I'm especially happy to be talking about such an important and topical subject. So I'm going to begin by talking about a few preliminaries. So first of all, I want to talk about what we mean when we speak of a secular democracy. So a secular democracy is a democracy that respects that its citizens have a variety of religious practices, beliefs, traditions, or none at all. But a democracy that does not impose anyone, or indeed any set of religious beliefs upon any unwilling citizen. So that seems to me to be the basis of a secular democracy. We can say that a democracy is a democracy that respects various religious practices, and that these various religious practices will have their own canons of law. So the Catholics have the canon law. Muslims have the Sharia law. But a democracy has its own canons of law, which we call civil law, that is separate from religious canons of law. So in a nutshell, it's a democracy that upholds the separation of church and state. Another important preliminary I want to make tonight is what I mean by saying that same-sex marriage is a requirement of reason. What I mean is that arguments for or against same-sex marriage have to be grounded in rationally defensible reasons. That is to say, reasons that are grounded on sound scientific and moral understandings. So as opposed to being grounded in irrational reasons like hatred or fear or bigotry. Thirdly, a very important preliminary is that all ethical reasoning is grounded in reason. And by this I mean that all ethical reasoning is subject to three principles. first of all, the principle of the universality of ethics. If something holds for one person, it holds for anyone else who finds themselves in the self-same situation. So, if I can't kill an innocent person, then you can't kill the innocent person either, even if you're richer or more powerful than I am. If I can't be enslaved, then you can't be enslaved, even though you're poorer or less powerful than I am. So ethics is universal in that way. At the same time, ethics is particular. So I want to talk about why these are not in conflict. The notion of particularism in ethics is the notion that some ethical requirement might hold in one situation, but might not hold in a different situation. So, if I'm not allowed to harm you because you pose no threat to me, that might still be compatible with the fact that she can harm you because you pose a threat to her. Or, if it holds of me that I can't be imprisoned because I've done nothing wrong, it doesn't mean that you can't be imprisoned if you've done something wrong. So, ethics is both universal and particular. Another important point about ethics is the idea that ethics is profoundly realist. There's a principle of realism in ethics. What we may do or may not do to something depends on what that something is. So, you can't throw a child or a live dog in boiling water and eat it. But you can throw a live carrot in a pot of boiling water and eat it. Well, that has something to do with the kind of thing that a child is and a live dog is and the kind of thing that a carrot is. And particularly, what we may or may not do to something depends on what that something is, not on what we think it is. So, for example, we tend to treat worms and chimpanzees on a morally equivalent level. And we're probably very much morally mistaken about this. Some higher animals clearly have rather developed moral sentiments that should have something to do with the way we treat them. And if you have any doubts about that, I encourage you to watch a new film you can see on YouTube called Blackfish. Very interesting film about our moral treatment of certain higher animals. So a consequence of realism in ethics is fallibility. Humans can make moral mistakes. We've made many moral mistakes in the history of humans. So for example, there was a time when we thought nothing of enslaving Africans because we had this notion that they were somehow subhuman. Now, it was never the case that Africans were subhuman. That was simply a mistake we made. So it was always immoral to enslave Africans, even though we didn't think it was. Now, whether such mistakes are morally culpable or not depends, I think, entirely on how negligent or self-interested we are in not seeking to inquire as to the nature of these things. And it was very easy at some point to not bother to ask the question whether Africans were really subhumans, because it was so much in our interest to think of it. And I think that we're in the same situation right now with respect to several animals. We are comfortably smug in not seeking to inquire about what kind of things these things really are, to continue treating them in morally dubious ways. But I think we're all making a moral mistake in doing that, and one that is quite morally culpable. All right, so this is about what I mean by, well, the idea that all ethical reasoning is grounded in reason. Now, I didn't know tonight where I was coming exactly and what kind of crowd I was going to run into, and so I thought it was important to make this assumption a preliminary. I'm going to assume that we have respect for gays and lesbians, that gays and lesbians are persons with human rights, and that they have the same rights as heterosexuals, other things being equal. So I wasn't sure if I was going to encounter lots of religious fanatics or something. So if you want to have an argument about whether homosexuality is sinful, I'll be happy to do that after. But I'm assuming a respect for gays and lesbians in this talk. So the question today is only whether same-sex couples satisfy the criteria for marriage. Now, I'm quoting Margaret Somerville, who, for some very bizarre reasons that nobody understands, is our spokesperson for ethics in Canada, and it drives most of us crazy. She's an ultra-conservative, ultra-religious Catholic. But even Margaret Somerville has come around to saying that if you reject same-sex marriage in order to affirm in the public square moral or other objections to homosexual people, then that's a failure of respect and that's discrimination. So that's not a grounds, according to even the religiously conservative Somerville, that can't be a reason to reject same-sex marriage. Okay, so that's all in line with the assumption that we all have respect for gays and lesbians. Now, there are two general kinds of arguments against same-sex marriage. One is a formal argument, and the other one is a substantive argument. So the formal argument is an argument from meaning. You will hear people say that the word marriage means a union of a man and a woman. Raise your hand if you've ever heard this argument. Marriage means a union of a man and a woman. So the union of a same-sex couple cannot rightly be called a marriage, because the word marriage just means. So this is an argument that appeals to our view of language. It appeals to the word marriage or our concept of marriage. I'm calling that the formal view. There's a different view. I'm calling that the argument from substance. This is the idea that same-sex couples are simply not the kinds of things that can marry. That marriage is a kind of relationship into which same-sex couples cannot enter. Okay, this is a kind of metaphysical understanding of what it is to be a same-sex couple, and a metaphysical understanding of what kind of relationship a marriage is, such that, metaphysically speaking, they can't belong to one another. So this kind of argument appeals to our view of the world, our conception of same-sex people, or gays or lesbians, and our conception of the kinds of relationships they're into. Now, we've seen exactly those kinds of arguments before. We've seen the argument from meaning, and I just thought I'd introduce the infamous Persons case in Canada. So in 1928, Emily Murphy, who was a judge in Alberta, I think, wanted to become a senator. And she applied to be a senator, but to be a senator, you had to be a qualified person. So then there was an issue about women, whether women counted as qualified persons enough to be senators. And 5 judges in Canada who heard the case, that was actually in 1926, 5 male judges who heard the case, dismissed the case. They dismissed the case based on the fact that the word senator had, since Roman times, designated men. Senators had always been men. And one of the justices wrote in the margin of the application that there was no word in Latin, there was no feminine version in Latin for the word senator. And on that basis, he just dismissed the application. Then the famous 5, or the valiant 5, they're called, 5 women, went to England, which was then, well, had some relation to Canada in terms of constitutional things. So they went to see the Lord Chancellor of the Privy Council of England, somebody called Viscount Sankey. And Viscount Sankey said that the notion that women weren't persons was, he said, a remnant of days more barbarous than ours. And so he declared that women were indeed persons, and so women became persons in Canada in 1928. Does anybody know when women became persons in the U.S.? Yes? 19?
I'm going to say, for example, 1920, when was the 21st? When
1921, you say?
yeah, or the 19th Amendment.
With the 19th Amendment?
I'm talking about the U.S.
Yes, in the U.S. It was with the 19th Amendment in
No, just for an example, that they were
They were allowed to vote then, but did their personhood come with the right to vote?
No.
Were they persons before?
Yeah.
I don't know when women became persons. I was thinking about that when I was driving over. I don't know when American women became persons. Anyway, I'll look it up. And likewise, you know, we've seen the argument before with the words citizen that had never before been applied to blacks because all the blacks were slaves, and how could you possibly imagine that these, you know, destitute people could be citizens, and so blacks couldn't be citizens because, of course, whatever. So it took until the Civil Rights Act of 1866 for blacks to become citizens. So, black citizens of America rejoice. You became official citizens 50 years before women became official persons in Canada. Okay, so we've seen the argument from meaning before. We've also seen before the argument from substance. We've seen it in when law schools did not admit women. They did not admit women, not because the word lawyer precluded the extension of the term to women, but because women were simply not the kinds of things that could become lawyers. They were, I don't know, too emotional, not intelligent enough for, you know, for whatever reasons, their being was meant to stay home with the kids, and of course they couldn't be arguing in a court of law. This kind of argument. We've also seen the argument from substance before with the miscegenation laws. I don't remember when they were, I think they were repealed in 1967. So that's not 50 years ago. Think about that. So an interracial union was not the kind of relationship that could be tolerated. It was not natural. And this case lasted until the infamous case of Loving v. Virginia, where Richard and Mildred Loving married, and they were sentenced to a year in prison because they had violated the anti-miscegenation laws of Virginia. And they were given a suspended sentence on the condition that they agreed to leave Virginia for 25 years. And they came back a couple of years later and fought the case in court, and of course that's in 1967 when the anti-miscegenation laws were defeated by the Supreme Court. Okay, so the argument from meaning in those terms appealed to our view or our concept of what a senator is, what a citizen is, and on the one hand, and the argument from substance, on the other hand, appealed to our view of the nature of women, that they couldn't be lawyers, of the nature of mixed-race couples, that they were unnatural or something. So we've seen these arguments before. So now I'm going to tackle the argument from meaning with respect to same-sex marriage. So the idea that marriage just is a union between a man and a woman. So, as a philosopher of language, as a linguist, I want to ask the question, how do we know this? How do we know that marriage just is a union between a man and a woman? Okay, so you say, well, we know this from history or precedent. It's always been the case, as far as we know. Actually, that's false. Women have married women and men have married men in history, but people who argue this seem to omit to mention that. Let's suppose it had been the case. Now the problem, even if that's the case, even if it were the case, that there had never been same-sex marriages in the history before, there's still a problem. The problem is that marriage was many things in the past before it became what it is for us today. So if you look at the history of marriage, it basically starts with some kind of loveless bartering of females against cows and camels. And it is still very much something close to that in certain parts of the world today. And then in in Europe and so on, it evolved into using females as currency and consolidation of families and wealth. And if you are as much of an addict of Downton Abbey as I am, you can see this is happening at the turn of the century, bartering women to consolidate families and wealth. And this is, marriage has changed over the years to become what it is pretty much in our understanding, at least in, our countries in the West today. Loving unions between mutually consenting adults for the purpose of taking care of each other and of children if there are any. So the problem with taking a word because, of what it denotes and fixing this in time is that words undergo semantic shifts. All words undergo semantic shifts. And my favorite example, I have two favorite examples of semantic shifts. One of them involves our notion of sofa. Raise your hand if you know what a sofa is. Okay. Well, you're wrong. Because a sofa is originally a cushion that you put on the back of a camel. That's what a sofa is. A sofa. But you see, you can see how the word sofa evolved from the from the cushion you put on the camel's back to be comfortable while you're traveling, all day long from one place to another. And then at the end of the day, you take the cushion and you put it in the sheep's tent. And then after a while, it gets tiresome moving around so much, so you become sedentary, so then the sofa stays in the tent all the time. And then, it doesn't have to be so small now that it stays in the tent, so we make it a bit bigger, make it a little more comfortable. And you can see how eventually it ends up in our living rooms, right? And likewise, another favorite example of semantic shifts is the word assassin. Now, I'm really fond of that word because it has its history in hashish eaters. The hashishim were people who would, eat hashish and then go on murderous rampages and rape and pillar. And so you can see how throughout history the hashishim, they went on murderous rampages and in a group of hashish eaters, and then, you know, they went on rampages alone, and then they went on rampages not necessarily after having eaten hashish, and they end up with our ordinary assassins. Nobody's going to tell you that he's not really an assassin because he didn't eat hashish before committing the murder. Okay, so the same thing with marriage. Marriage, you know, it has its history and it changes over time. And so the problem with saying marriage just is that there's no such thing. Okay. Another problem with the just is notion is that marriage is still in many places today different things than it is here. And we still call those things, even though they're very different from our understanding of marriage, we still call those marriages. So for example, the Hmong in northern Vietnam and China, they marry their children when they're, 8 years old. And they have a good reason for doing that, because they marry the kids end up growing together in the same family. They don't have sex at 8 years old, they're just married, and they get to grow up as brothers and sisters, and by the time they're old enough to have sex and have children, they're used to each other. Okay, now, it wouldn't be legal to do that in the US or in Canada, but there are still marriages. We understand that these Hmong children, this 8-year-old little girl and this 8-year-old little boy are married. We're capable of understanding that, even though we don't have this institution. And, we've had Taliban marriages of 8-year-olds to old men. These kinds of marriages make me sick personally, but they're still marriages, even though they're not the kinds of things that we're used to. And there are arranged marriages between non-consenting people all over the place, and they're still marriages, even though they're not the sorts of ideal things we would consider marriage. And, we all know that they are married used to mean that they're indissolubly married forever, and now they used to be married made no sense, because there was no such thing as used to be married unless you were dead, maybe. But now we countenance that people used to be married, and they are no longer, because now we have divorce, and they used to be married can be said of about 40% of couples. So, marriage changes. Okay, so I want to focus on the argument from meaning. In the courts in Canada, this was called it was referred to as the definitional preclusion idea. So, for example, the people who were arguing against same-sex marriage cited the dictionary. So here's the dictionary in the Oxford Canadian Dictionary. It says the legal or religious union of a man and a woman in order to live together and often to have children. Now, that's a dictionary entry of marriage, and as a dictionary entry goes, it's pretty run-of-the-mill. Now, here's a big problem with the notion that because that's the definition of marriage, it precludes gays or same-sex marriage. Dictionaries do not provide definitions in the sense of necessary and sufficient conditions. Dictionaries provide stereotypes. And as a stereotype, it's not a very good one. Because, or at least as a definition, as a case of necessary and sufficient condition, I'm sorry, I misspoke. It's a pretty good stereotype, but it's not a good definition if by definition we need a necessary and sufficient condition. First of all, the definition is over-inclusive. Religious unions are not legal marriages. You have to do an extra step of making a religious union legal before it's a marriage. So religious unions are not legal marriages. The definition is also under-inclusive, because married couples needn't ever live together, and they're still married, and they would remain just as married if all and only unmarried couples have children henceforth. So it's neither necessary nor sufficient to have children, to live together, to be married. Okay, just to drive the point home that dictionary entries are not definitions. So this is a bit excessive, but it's it's part of my professional shtick. Here's the entry under Merriam-Webster for kangaroo. Right? It says it's a decent definition, I mean, or dictionary entry. Any of several large leaping marsupial mammals of Australia with powerful hind legs and a long, thick tail. Okay, well, that's a stereotype of a kangaroo. But as a definition, if by that we mean a necessary and sufficient condition for being a kangaroo, it's astoundingly false. No kangaroo would be any less a kangaroo were we to discover that kangaroos actually originated in India, or even that every kangaroo that's in Australia right now has been shipped from India. Nor is it essential to any kangaroo's being a kangaroo that it have any legs, much less powerful ones, or any tail, much less a long and thick one, or that it be able to leap. If kangaroos universally evolved weak hind legs, thinned or shortened tails, and an inability to leap, they would perhaps be sickly kangaroos, but no less kangaroos for all that. Okay, so at best, dictionary entries accurately represent stereotypes, but stereotypes are not meanings. So the Oxford Dictionary definition, or the entry rather, for marriage is inadequate. It's inadequate without supplementation of the word typically. So marriage typically is a union of a man and a woman in order to live together and often to have children. But the addition of typically reveals its status as a stereotype rather than a definition. And the inclusion of typically undermines the essential heterosexuality of the definition. The fact that marriage is typically heterosexual does not mean it cannot sometimes be same-sex, any more than the fact that marriage is typically entered into in youth does not mean that it cannot be entered into in old age. Moreover, the Oxford Dictionary entry is simply, as of today, empirically inadequate. It's inaccurate. The fact that some same-sex couples are now legally married in the Netherlands, in Belgium, in Spain, in Canada, in New York, in Massachusetts, I think, is something that all dictionary entries for marriage henceforth will have to acknowledge on pain of being factually mistaken. Okay. Now there are currently there are many different concepts of marriage, and I think a lot of the debate on same-sex marriage is a confusion between different kinds of concepts of marriage, different words, marriage. So there's the Catholic concept of marriage. Under this Catholic concept of marriage, this is a concept that disallows divorce, disallows polygyny, the marriage of one man to several women. And what is disallowed or allowed under the Catholic notion of marriage is determined by authorities on canon law, the Pope and the cardinals and whoever is in charge of determining the parameters of canon law. Likewise, there's a Muslim concept of marriage, and it's a different one. This one allows divorce and polygyny. So it's a different concept of marriage than the Catholic concept, and likewise, what it allows and disallows is determined by authorities on Sharia law. And then there's a third concept of marriage, which is the legal concept of marriage. Let's call it the civil concept of marriage. This civil concept of marriage is a different concept, witness the fact that it allows divorce, but at least now disallows polygyny. So it's a different concept of marriage. And this one is a concept whose parameters are determined by authorities on civil law. And who are the authorities on civil law? Well, our governments, that is to say, through us, and our courts. Okay. So, the only question of relevance in a secular democracy is whether same-sex couples can be married according to the civil concept of marriage. Whether they can be married according to the canons of civil law. Now, because just as our governments and our courts have nothing to say about whether, what the parameters of marriage are under canon law, they're not experts. Our judges are not experts on canon law. our judges are not experts on Sharia law. In the same way, Catholic judges are not competent with respect to our civil law any more than the imams are competent to determine the parameters of civil law. So our courts and our governments are the authorities with respect to civil law. And the important piece here is that civil law, any civil law, is governed by constitutions and other human rights protections of various sorts. So, in civil law, no word in a law of civil law is allowed to discriminate against individuals. You can't have a law in a civil law that will apply to everybody except fat people. That's not allowed because, because the Constitution and so on forbids there being that kind of concept in our laws. And no concept in civil law is allowed to discriminate against individuals, other things being equal. So the question is really about whether in same-sex couples, when we're thinking about marriage, other things are equal or not. Unless it can be shown that other things are not equal, then same-sex couples must be allowed to marry. So the onus is to show that there's something about same-sex couples such that things are not equal with respect to marriage. Okay, so the question is, are other things equal in same-sex couples? Now the answer to that cannot be no, other things are not equal because they're same-sex couples. Okay? That's a fallacious answer. That's a circular answer par excellence. They can't marry. Same-sex couples can't marry. Why not? Because they're same-sex couples. Okay, that's just a non-starter. That's like saying that women can't be lawyers because they're women, or gays can't marry because they're gay. That's circular. You have to provide reasons why being a same-sex couple makes a relevant difference. So that's different. Here's an example where you might say things are not equal. There is a relevant difference. Men don't get pregnancy leave because they don't get pregnant. Now that's a relevant difference. Okay? All right. So here's an example of the kind of fallacious reasoning I'm talking about. So Somerville says at some point that gays and lesbians are precluded from marrying because marriage is sacred. Okay? Now, to say that you can't pee because P is X, so, for example, you can't, you say to a kid, you can't climb Mount Everest because it's difficult, or you can't watch, Breaking Bad because it's too late, or you can't, throw yourself in the lake here because it's deep, or you can't marry because it's sacred. That implies that that it's too difficult. You can't climb Mount Everest because it's too difficult for you. You can't watch Breaking Bad because it's too late for you. You can't jump in the pool here because it's too deep for you. Well, so when you say that gays can't marry because marriage is sacred, you're saying that marriage is too sacred for gays. It's not too sacred for non-gays, but it's too sacred for gays. So this is circular, right? You have to provide reasons why it's too sacred, and the reason can't be because they're gay, because that's circular. All right. So basically, all the arguments from meaning are circular. You can't marry because marriage just is a union of a man and a woman. Well, that's circular. If gays can marry, then marriage is not a union. It's not just a union between a man and a woman. Okay? So all the arguments from meaning are circular. So now I'm going to look at the argument from substance. the argument from meaning and the argument from substance both engage in the same circular logic. They're just different versions of the same fallacious reason. So here's the argument from substance. Somerville again, she says, at the heart of the disagreement between people who support same-sex marriage and those who oppose it is whether the fact that opposite-sex couples represent a naturally, inherently procreative relationship, and same-sex couples do not, constitutes a difference, a relevant difference that justifies separate institutions. So marriage for opposite-sex couples and civil unions, or whatever you want to call them, for same-sex couples, that both would publicly recognize committed adult pair bonding. Okay, so she's saying that there is a relevant difference. The relevant difference is the fact that opposite-sex couples represent a naturally, inherently procreative relationship. But same-sex couples do not. Okay, so that's the relevant difference. I want to argue, I'm going to show to you that this is just bogus. Okay? So we're going to ask, what are inherently procreative relationships? And is marriage ever an example of an inherently procreative relationship? Well, let's look at a clear example of what it is to be an inherent fact. Okay, here's a clear example of an inherent fact. It's the fact about me that I'm the product of the actual egg and the actual sperm that united at conception to make me. Okay, I'm appealing here to an intuition you all have. Okay, just imagine that at the time of my conception, you know that, I don't think this is news, that at the time of my conception, there was one egg and 200,000 sperms vying to fertilize that egg. Right? And one of the 200,000 succeeded and made me. Right? Now, imagine that instead of that sperm fertilizing the egg, it's the one next to it that had succeeded in fertilizing the egg. Okay? Now raise your hand if the result would have been me. Okay, the result would not have been me. The result would have been someone, like some kind of weird twin of me. But I would not have existed if the other sperm had fertilized the egg, right? I would not be here. The conditions that are inherent to my being here is that the actual egg and the actual sperm that fertilized each other have happened. Okay, that's a condition that's inherent to me. All right. So my actual gametes, the actual egg, the actual sperm, are an essential condition of my existence. As a matter of metaphysical necessity, this egg and that sperm are inherent to my being. Okay, that's a clear case of something being inherent. Okay, is marriage ever inherently procreative? Now, what's the sense of inherently procreative? To say that procreation is inherent to marriage is to make procreativity a necessary condition for the existence and persistence through time of any given marriage. It's to make procreativity metaphysically necessary for the conditions of identity of a marriage. Now, there are two senses of procreative. One sense is factive, okay? You're procreative because you've procreated. Okay, so this implies the existence of progenitor. That's the factive sense of procreative. You procreated. Now, if that's the sense that procreative that we mean when we talk about marriages being inherently procreative, well, a relation whose metaphysical condition of identity is to procreate, but which does not procreate, is more than a failed relation, it's no relation at all. Okay? So anyone who thinks that the essence of their union is to produce children is mistaken. Unless they're ready to consider their marriage as having never existed as a marriage at all, should it result in no children. Okay? All right. So that can't be the sense of procreative that's involved here. Because nobody gets married and wonders whether they're truly married until they have children. Okay, which would have to be the case if that's what we meant by inherently procreated. You wouldn't know if you were really married until you procreated. Okay, so that can't be what's meant. So what's meant? So what's meant has to be the other sense of procreative, where you're not procreative because you procreated necessarily, but because you have the potential to procreate, whether the potential is ever actualized or not. Okay, so this is the potential sense of inherently, potentially procreating. But of course this won't do. Not all married couples have the capacity, even in principle, for procreation. We allow octogenarians to marry while they have no natural procreative potential whatsoever. They're not going to reproduce. They're still married. They can marry when they're 80 years old, and nobody will question that they're married, even though nobody thinks they're inherently procreative, even in the potential sense. Moreover, absent a check of fertility potential before marriage, no two people know that they are even in principle capable of procreating. And given infertility rates, plus the fact that some people who are individually fertile may not be compatibly fertile, heterosexual couples do not know that they are potentially procreative together. But we don't require procreative potential compatibility checks before we allow people to marry. Okay, so even being potentially procreative is not a requirement for marriage. Okay, so we know that the potential for procreation is not a necessary condition for the existence of a marriage. Now, moreover, with technology, and certainly in the case of lesbians, very minor technology, like a turkey baster, there is potential for procreation. So that's why Somerville now requires the qualificative natural. So it's not enough that you have that the relationship be inherently procreative. It has to be naturally inherently procreative. Now, what does she mean when she says it has to be naturally procreative, inherently procreative? Well, that's code for it has to have the capacity in principle, not necessarily in fact, but just potential, to procreate without third-party intervention. Okay, that's what she means by natural. If it's going to be natural, it's got to be the case that you can procreate, you have the potential to procreate naturally without third-party intervention. Okay. Now the requirement that to marry, you have to have the capacity in principle to procreate without third-party intervention is roundly disingenuous. We don't expect couples to get divorced once they realize that they cannot naturally procreate together. Which we should do, because then we realize that they were never married to begin with. We even judge as contemptible husbands who divorce their wives for this reason in cultures where this happens. Which we ought to find perfectly reasonable if natural procreation is of the essence of marriage, as perfectly reasonable as firing a housekeeper who doesn't clean the house. So inherent to marriage, at the best of times, is only the desire to be naturally procreated. But desires are just desires. And besides, we marry people who explicitly deny having any such desire. Now, if you didn't think it was clear enough that the capacity in principle to procreate without third-party intervention is completely disingenuous. So we allow all sorts of couples to marry. We allow octogenarians to marry. We allow infertile individuals to marry. We allow people who are individually but not compatibly fertile to marry, despite the fact that they lack the capacity in principle to procreate without third-party intervention. Now, what distinguishes octogenarians and infertile couples who are going to have to procreate only through in vitro fertilization or something like that? What distinguishes same-sex couples from them? Now, in the same-sex marriage in Canada, I'm ashamed to say that the answer that the Attorney General of Canada gave to that question was that octogenarians and infertile individuals and individuals who can only reproduce through third-party intervention belong to a group that has the capacity in principle to procreate without third-party intervention. They belong to a group, but gays and lesbians don't belong to that group. Now, thankfully, the belongs to a group that has the rational capacity to procreate without third-party intervention, that distinction did not much impress the judges. The disingenuousness of the distinction was hard to keep disguised when the Attorney General of Canada found herself actually saying in court, I heard her myself, she said, I know it sounds lame, Your Honors, but... Now, if same-sex marriage were unreasonable, it wouldn't take such unreasonable arguments to prove it. Now, why is it that octogenarians, why would anybody think that octogenarians, an infertile couple, belong to a group that has the natural capacity and principle to procreate without third-party intervention, but that gays and lesbians don't also belong to that group? Why would anybody think that there's a group that these people belong to, but gays and lesbians don't belong to? Well, the answer, of course, they don't belong to that group because they're gay. And now we've come full circle. Why can't gays marry? Because they're gay. Okay, so I'm coming to my conclusion. My conclusion has to do with, broad facts about the connection between words or concepts and how we think of things in the world. So there's a grade 8 project you've probably heard about. It's a project that's dedicated to the inclusion of apes into the category of persons. Okay? Now, people who would deny apes the status of persons have to do so based on their implicit or explicit views about apes. They can't just rely on their conception of what it is to be a person. They also have to rely on their conception of what it is to be an ape. No conception of personhood excludes apes all on its own. Right? Likewise, no conception of marriage excludes same-sex couples all on its own. What we find primitively compelling about the notion of marriage is inseparable from how we represent to ourselves the moral status of gay and lesbian relationships. No notion of marriage excludes same-sex relationships on its own. I've heard lots of people say, yes, but why do they want our word? And of course, we all know what that is. It's about separate but equal. There's no such thing. but not marriage, unions for gays and lesbians, such as are proposed under registered domestic partnership schemes, demean gays and lesbians just as surely as refusing to call women persons did. One of the intangible benefits of being married is precisely that of having one's union recognized as a marriage, to have that word applied to it. So what we're seeing in the marriage case, in the same-sex marriage case, is the person's case all over again. And the exclusion of gays and lesbians from the institution of marriage is, as the Lord Chancellor of the Privy Council wrote in 1928 about the person's case, a relic of days more barbarous than ours. And to paraphrase Viscount Sankey further, we can say those who would ask why the word marriage should include gays and lesbians, the obvious answer is, why should it not? Thank you very much for your